Hello, everyone. Today we're going to be discussing legal controls and freedom of expression by Nico, Maria, Gerardo, Mariah, and Shannon. Important laws in court cases. The federal election law, originally introduced to try and limit the amount of money people can contribute to a political organization. Buckley versus Valeo. This is Congress's attempt to limit the amount of money an individual can donate and would have to report this information to the Federal Election Commission. I'm going to be talking more about both of those in the next two slides. Citizens United versus the Federal Election Commission, 2010. This was a 5-4 decision, stated that it would violate the First Amendment if Congress were to limit spending for TV and radio advertising. This is virtually every means of communicating ideas in today's society requires the spending of money. So, federal election laws. The first federal campaign finance legislation was in 1867. This was originally implemented to prohibit federal workers from requesting donations from Navy Yard workers. Over the next 100 years, we implemented multiple laws to regulate the financing of elections and campaigns. The three main focuses were to limit contributions, to ensure individuals or groups did not have an unfair influence on federal elections, control campaign spending, and require public disclosure of campaign finances. In 1907, the Tillman Act, this prohibited corporations and national banks from contributing money to the federal campaigns. In 1971, this provided the basic framework for PACs, or political action committees. These are basically a way to get around the Tillman Act for large companies to put their money together and donate it to a constituent or a party. In 1974, it created an independent body to monitor federal election laws. With the campaign abuse in 1972 with the Watergate scandal, the Federal Election Commission was implemented to ensure all election finance laws were being followed. The members of this commission were appointed by Congress. Buckley versus Valeo. This court case was introduced in 1975 and decided in 1976. The question in the court was, did the limits placed on electoral contributions and spending in the Federal Election Campaign Act of 1971 violate the freedom of speech and association clauses? The court ruling came down to three important conclusions. First, limitations on individual contributions to political campaigns did not violate the First Amendment, since the limitations of the FECA enhance the integrity of our system of representative democracy. Second, the limitations of spending from their own resources did violate the First Amendment, since these practices do not necessarily enhance the potential for corruption that individual contributions to candidates do. The court found that restricting them did not serve a great enough interest to limit. Third, the FECA violated the appointment clause because most of the commission members were not selected by the president, and it states in Article 2, Section 2 of the Constitution that only a president can appoint officers of the United States. The members of the FECA were officers because they were given enforcement authority.
Film and the First Amendment. Back when the Bill of Rights was ratified, our nation's founders could not have predicted the advent of visual media. Film, which came to existence in the late 1890s, presented new challenges for those seeking to determine whether expression in a film should be protected. The First Amendment said nothing explicit about film, so lawmakers, courts, society, and industry began an ongoing struggle over exactly how to apply it. As new communication technologies emerged, so did the concerns over the impact of the film on values and moral of the public, especially children. Citizens and lawmakers controlled the movies. During the early part of the century, civic leaders in the industry and towns formed local review boards in which they would screen movies to determine their moral suitability for the community. By the 1920s, more than 90 cities in the United States had such boards. They were composed of vice squad officers, politicians, and citizens. And by 1923, 22 states had such boards. Meanwhile, lawmakers seeking to please their legislations and control of films. For example, African-American heavyweight champion Jack Johnson defeated white champion Jim Jeffries in 1910. The federal government outlawed transportation of the boxing movies across the state line. This move was reflected racism attitudes, a fear of images of black men defeating a white man. More than a distaste for violent imagery, the legislators pondered to white constitutions who saw Johnson as a threat. The idea of the film as free speech took a big hit in 1915 when the Supreme Court decided in a Mutual versus Ohio case that films were a business pure and simple and not being protected by the First Amendment. The movie industry regulates itself. In the early 1920s, a series of scandals, including a rape and murder of an aspiring actress at a party thrown by a silent film comedian, Fatty Arbuckle, rocked Hollywood and pressured the movie industry to regulate itself before public review board or the government would take force and regulations on it. Over the next few decades, the industry set up its own way of policing not only the contents of the film, but personal lives of actors, directors, and others involved in the movie-making process. Censorship. First, censorship. In the United States, the First Amendment theoretically prohibits censorship. Over time, the Supreme Court decisions have defined censorship as prior restraint, meaning that the court and government cannot block any publication or speech before it actually occurs. The principle behind prior restraint is that a law has not been broken until an illegal act has been committed. However, the court left open the idea that the judiciary could halt publications of news in exceptional cases. For examples, if such publications would threaten national security, in the 1970s, two pivotal court cases tested the idea of prior restraint. Those were the Pentagon Papers decision and the Progressive Magazine's decision. First Amendment versus Sixth Amendment. First Amendment protections of speech and the press have often clashed with the Sixth Amendment, which guarantees the accused individual of all crimes, prosecutions, the right to a speedy trial, and an impartial jury. Gag orders, shield law, and governing use of cameras in the courtroom all put restrictions on speed and other forms of expression for the sake of the Sixth Amendment rights. Gag orders lawyers have used in the news media to comment publicly in a case that is pending or in trial. This can be difficult to assemble an impartial jury, thus threatening the individual's Sixth Amendment right. A gag order is used to prohibit the press from releasing information or giving commentary that might persuade the jury selection, or cause an unfair trial. Gag orders have been struck down and as prior restraint violations of the First Amendment. Shield laws state that reporters do not have to reveal the source of the information that they use in a news story. The news media have argued that protecting the source's confidentiality maintains reporters' credibility. Protection sources have possible retaliation and serves the public interest by providing information citizens might not otherwise receive. Laws governing the use of cameras in a courtroom. Debates over limiting electronics broadcasting equipment, photography equipment in the courtroom date back to the trial of the mid-1930s. It was decided that electronic equipment in the courtroom distracts the essential dignity of the proceedings.
The becoming of freedom of expression, press, and speech. Freedom of expression is the right of individuals and organizations to exchange information without fear of repercussion or censorship. That right involves not only expressing thoughts and opinions and disseminating information, but also searching out information, observing it, and listening to it, such as in a lesson or a public address. Many people have pondered the meaning freedom of expression. The Supreme Court has regarded creative freedom as a form of expression in its broadest sense. In most circumstances, freedom of expression can only be limited if it will result in immediate and direct harm. The Supreme Court relies on a principle known as content neutrality when resolving matters affecting creative freedom of expression. Content neutrality means that the government cannot prohibit or restrict expression just because some people find it offensive. To comprehend how the concept of free expression has evolved in the United States, we must first interpret the concept of free press. Fun fact, the ancient Greeks were the first to advocate for free speech as a democratic value. Free speech, or to talk candidly, what the ancient Greek word parrhesia meant. According to the book, in chapter 13, it indicates that in the 1600s, several European national governments sought to regulate the flow of ideas through the press by requiring printers to obtain licenses. Their mission was to keep an eye on what editors and authors were saying and to put a stop to any insurrection. To publish any form of press in the mid-1600s, you need a license. In 1695, England used to license press freedom, but they eventually stopped. After a few years, the United States Constitution established the right to a free press. They did, however, ratify some of the protections in the U.S. Constitution. The states pushed for official federal free speech, which persuaded the press to approve what is now the new Congress's first session. But their efforts paid off, and the amendment is now one in the first 10 to the Constitution. The First Amendment protects press freedom, which is essential to a democracy in which the government is held accountable to people. What does this imply in today's world? In general, it means that the government cannot imprison, penalize, hold people or organizations liable for what they say or publish unless they are extraordinary circumstances. The ability to express our opinion and speak freely is essential to bring about change in society. Free speech, press, expression has always been important throughout history because it has been used to fight for change. Freedom of press is important till this day. Being informed ensures people understand the issues at hand and what policies and politicians best represent them. When we talk about rights today, they wouldn't have been achieved without free speech.
Violation Violation of privacy rights. Right to privacy. A person's right to be left alone without his or her name, image, or daily activities becoming public property. One of the most common ways to invade someone's privacy is unauthorized tape recording, photographing, or wiretaping of someone. Other common ways of privacy invasion are making someone's personal health or phone records available to the public. News media has been granted protections under the First Amendment to practice their work, even if it constitutes the violation of someone's privacy, which oftentimes occurs to private individuals and public figures. Due to this, many municipalities and states have passed anti-paparazzi laws protecting public individuals. The Privacy Act of 1974 protects individuals' records from public disclosure unless they give a written consent. However, the USA Patriot Act of 2001 weakened privacy laws, giving federal government latitude in searching private citizens' records and intercepting electronic communications without a court order.
In 2016, an entertainment gossip blog called Gawker invaded Terry G. Bollea's, also known as wrestler Hulk Hogan's, privacy. In 2012, Gawker posted a video on his blog of Bollea having sex with his best friend's wife. Gawker argued in court that his actions were protected by the First Amendment. He also argued that Bollea often publicly talked about his personal sex life in media interviews. However, the jury voted in Bollea's favor. They determined that Bollea's privacy was indeed violated, causing both emotional and economic distress to his life. Gawker and Bollea reached a settlement of $31 million. In 2016, there was another instance where the FBI and Apple had a standoff over getting access to an iPhone that was recovered in San Bernardino, where a terrorist attack took place. A court ordered Apple to create a software key to allow the FBI to unlock the iPhone. Apple responded that writing such software would make all iPhones subject to FBI scrutiny and susceptible to hackers. In 2018, Apple announced it would close the software loophole that enabled the FBI to gain access to the iPhone.
Protected forms of expression. Regardless of the First Amendment, the federal government, as well as the state laws and local ordinances, curb expressions. U.S. court system states that some of the expressions are not worthy under the Constitution. The forms are sedition, copyright infringement, libel, obscenity, and the violation of privacy rights. Sedition and copyright infringement. Sedition. Congress had passed no laws that were prohibiting publications of dissenting opinions. Schneek versus United States in 1919. This case had to do with a Socialist Party leader named Charles, who was convicted of urging American men to protest the draft, and for that was sentenced 10 years in prison. Justice Oliver Wendell Holmes then noted that they were all entitled to the First Amendment only during times of peace, which led the Supreme Court to then indicate the First Amendment's limits. Copyright infringement legally protects the rights of authors and producers to their published or unpublished music, writing, lyrics, etc. In 1719, authors had the right to control their works for 14 years with an opportunity to renew copyright protection again for another 14 years. After that, they would enter a public domain, meaning that it's free access to the public. In 1976, Congress then extended the copyright period to the life of the authors plus another 50 years, which obviously gave the authors and publishers more time. And in 1998, Congress then extended the copyright period at another 20 years for the reason being that works as Disney's Mickey Mouse were set to expire. After January 1st, 2019, nearly every digital culture curates questions about the copyright law. Till this day, there are still individuals who tend to copyright digital content, such as movies, and that is when individuals are questioning if news like Google News or Facebook should start paying for linking articles that they personally did not write. Libel. Defamation of someone's character in written or broadcast form. It is a false statement that holds a person up to public contempt, hatred, or that injures a person's livelihood. Some examples of libel would be falsely accusing someone of professional incompetence, falsely accusing a person of crime, falsely stating that someone is mentally ill or engages in unacceptable behavior, falsely accusing a person of associating with a disreputable organization or cause. In 1964, the city commissioner of Montgomery, Alabama, L.B. Sullivan, to sue the Times for libel. He claimed the ad was directly towards him, and the court awarded him with $500,000. However, it was reversed because it had violated Times' First Amendment right. During the Sullivan case, the Supreme Court then asked future civil courts to tell apart whether libel cases are private individuals or public officials. Private individuals that include city sanitation employees, undercover police informants, and nurses had to prove these three things to win a libel case. 1, that the public statement about them was false. 2, that damages or actual injury occurred. 3, that publisher or broadcaster was negligent in failing to determine the truthfulness of the statement. Examples that were also given were when actor Johnny Depp was accused of assault by his ex-wife Amber Heard. In 2018, Depp brought a libel lawsuit to the tabloid newspaper, and in 2019, Depp filed a $50 million lawsuit against Heard for libel. Obscenity. Current legal definition from the 1973 Miller v. California case. Obscene materials meet 3 criteria. 1, the average person applying contemporary community standards, finding that material as a whole appeals to prurient interest. 2, the material depicts or describes sexual conduct in a patently offensive way. 3, the material as a whole lacks serious literacy, artistic, political, or scientific value. Many legislators argue that it's not protected by the First Amendment. However, experts can agree on obscene work since it's been changed many times over the years. After the Millers v. California case, the Miller states that the obscenity has been rare, but the cases of sexting was a new complication which then led to minors producing and sending sexually graphic images and videos of themselves to others through cell phone or through the internet.